Good evening, everyone. This is John Milburn for Laws 12065. This is Foundations of Property Law. It's our final session in Term 1, 2020. Thank you all for joining me for the live session. And as you know, next week I will release the take-home paper. I'll speak more about that shortly. Also, if you have been watching your emails, you should be aware that I've released the assessment results, feedback and information guide or assessment guide in relation to the second assessment as well. Last week we talked about a range of issues that are available, particularly in the equitable jurisdiction. And I just want you to also be aware, and this isn't an exam hint per se, but I want you to be acutely aware of the importance of the Australian consumer law in not only foundations of property law, but generally in terms of remedies that are available in a wide range of areas of practice. And it's often overlooked. And because of cross-vesting jurisdiction, the Australian consumer law has wide application both at a federal level and a state level. And you're probably aware that the ACL has been incorporated into state legislation, specifically in Queensland in the Fair Trading Act. So the main area of relief under the Australian consumer law, or the ACL, relates to those things that might be done in contravention of chapters 2 and 3 of the ACL. Essentially, amongst other things, people can obtain damages, but there are limitations, and remember there's a 6-year limitation for any action for damages under the ACL. But there are a wide range of discretionary orders available to courts under the ACL as well, particularly if there are contraventions of chapters 2 or 3 or 4 of the ACL. So somewhere in your toolkit, I'd urge you to incorporate some provision that at least reminds you as to the potential for exercising or asking a court to exercise some or more of these wide-ranging powers that are discretionary to them. So in the context of property law, we're generally dealing with contracts, and the ACL provides for powers of a court or tribunal to declare contracts wholly or partly void, to vary the contract, to refund money or return property, to order payment of compensation or repairs or provision of parts. So there are a whole range of matters that might be considered. In terms of getting your foot in the door, an important provision of the ACL is section 236, because it provides for what an applicant needs to establish in terms of loss or damage. And essentially it needs to be an issue of matching the damage to the causation. And by that I mean that it's all very well to say, well, I've suffered loss or damage, but you need to establish the causation, meaning that you can attribute that loss or damage to the respondent's conduct. So have a look at ACL section 236, which provides for that causation link between damage and the contravention. And a very important example, a very commonly used example, is because there's reliance upon the respondent's misleading conduct. So there are very broad provisions to deal with very broad contraventions that might be available. So you'll see in section 236 that simply a person who suffers loss or damage because of prohibited conduct, such as misleading or deceptive conduct, may bring an action for damages. So it's very, very broad, and you can see how that might impact on property matters. An injunction may be available to a party to restrain another engaging in prohibited conduct. So have a look at section 232 in that regard. And if prohibited conduct, as I've mentioned it, is established, courts can make a whole range of orders. And have a look at section 243 of the ACL. So in the context of property law, the court has power to declare contracts to be void, vary the contract, refuse enforcement, direct payment of money, etc. So 236, 232, 243 are all sections of the ACL that work in together. And also bear in mind that when it comes to seeking injunctions under ACL 232, many of the common law principles that apply to injunctions would be considered by a court in the context of that application. Remember also that when we're dealing with property issues and breaches, and if you're trying to work out essentially who's right, who's wrong, then you need to consider the aspect of who has the onus of proving something and what is the standard of proof. So generally speaking, if, for example, you're a judge or a magistrate or a tribunal member, you've got to bear in mind that if, generally speaking, someone is bringing an application to you. So does that applicant have the onus of proving the case? In other words, if you can't decide, then it probably means that the applicant hasn't fulfilled the onus of satisfying you to the requisite standard. And the requisite standard in civil proceedings is on the balance of probabilities. And if you're thinking about onus and standard of proof, again, another matter that you might include in your toolkit is a reference to the test laid out in Brigginshaw. I suspect that you've probably heard this test, but the test in Brigginshaw and Brigginshaw, or the Brigginshaw test, comes from a case of Brigginshaw and Brigginshaw. The citation is 1938, 60 CLR 336. 1938, 60 CLR 336. And essentially this test is concerned with the higher or lower standard of evidence required to satisfy a court or tribunal. Hello, can you hear me? Can you hear me? Sorry, I lost the connection. It says it's still recording. I just wanted to confirm.
John, your screen is freezing.
Is it? All right.
You mightn't have the bandwidth.
Yes, I think that's the issue. Obviously, I'm not at my usual chambers. I'm going to take away the vision, so that might help with the quality. So I'll just stop the video recording, and hopefully you can hear me. So are you able to hear me now?
Yeah, that's fine, John. Loud and clear.
Thank you very much. My apologies. I'm working off, I'm tethering and all sorts of things here. So I hope that you didn't lose too much, but I was talking about the test in Brigginshaw, and Brigginshaw is all about the level of proof. The standard of proof, being balance of probabilities, doesn't change by Brigginshaw, but Brigginshaw establishes this general principle that the level of evidence, or the standard of the evidence, the quality of the evidence to satisfy a court or tribunal on that balance of probabilities is dependent upon the seriousness of the matter being determined. So in simple terms, if we're dealing with a low-level case, not very much money involved, for example, even though the tribunal or court needs to be satisfied on the balance of probabilities, you don't need to produce a whole lot of evidence. There might be 5 witnesses that could help, but a court might be satisfied with just the evidence of 1. But if we're dealing with something very substantial, then a court may want to ensure that it has very good and extensive quality of evidence, even though it's still determining the matter on the balance of probabilities. So keep that in mind. That's Brigginshaw. Shortly, I'll be talking about the exam and general exam techniques, but finally, I want to emphasise the importance of some of the websites that you'll need in practice. And arguably, these websites will serve you more than, say, your textbook into the future. That's not meant to be a criticism, but just a statement of the reality that things like the information on the Department of Natural Resources, Mines and Energy is very valuable. And last week, I recall, I directed you to consider the Land Title Practice Manual, which includes some excellent practical commentary and provides information on a range of topics that we've dealt with in this unit. It also includes forms and how to complete those forms. So that concludes the substantive content for the unit. I'll now talk about the exam and exam techniques, but before I do, are there any questions? All good? All right. If you do have questions, please unmute your microphone or ask through the chat facility. So firstly, the exam. Take-home paper, I will release it next week, Thursday the 11th of June, Queensland time, at about 6:45 p.m. It's due Friday the 12th of June, 11:45 p.m. So about 29 hours. Bear in mind two important things. The first is there are no extensions, and secondly, no late submissions. So please don't leave it until the last moment if you can help it. If you can submit a little earlier, do so just to be safe. Maximum word limit, 3,000 words. If you go a little more, I won't be overly concerned, but bear in mind that I will be changing my focus a little if you go over the word limit. If you do that, I'll be much more critical of the way in which you've used the words, and I'll be asking myself whether you really need to go to 3,200 words. And then I'll be looking to see if you've wasted some words, added words that were not necessarily written in the passive voice instead of the active voice. So it's probably worse for you if you go over than if you stay under the word limit in that sense. 3 questions. Question 1, worth 30 marks, 1,500 words, and I'm asking you to prepare a judgment. You'll note the spelling of judgment in the context of what a judge writes. There's only one E, so it's Judgement. It's not Judgement. Judgment with the 2 E's means exercising a discretion. Judgment without the middle E means writing a decision of a court. Keep that in mind. So what you ought to do as the judge is make a clear decision in relation to the scenario that I present to you. Good question. How strict will I be on AGLC 4? In short, very strict. But can I say that this cohort is excellent on legal research referencing. Collectively, you're doing a very good job. So don't be concerned that I'll be looking strictly at your compliance with AGLC 4. And I know, Lachlan, there was a bit of tongue-in-cheek in your question in that because you knew that I'd be looking at that pretty carefully. So in the first question, you're the judge. You need to make a very clear call who wins and why. And in any decision that a judge writes, you need to satisfy the requirements of fulfilling the basic task of identifying the key facts, identifying the legal issues, finding the rules and mentioning the rules, applying the law and coming to a conclusion. Now, I know that's all very familiar because that's basic IRAC methodology. But if you look at a judgment, it's very rare that you would actually see a judge write with those specific headings. It's more blended in, but that's the legal methodology that's used. So in this scenario, you'll need to consider issues around possession of property. It's in the context, it's against the background of a recently completed real estate transaction. You'll need to give consideration to fixtures and fittings. There'll be this blurring of the line between real property and personal property, and there'll be competing interests from a number of parties in relation to an item or items, and there will be a security aspect involved given the application of the PPSA. So a number of parties will put forward different claims. You need to identify ultimately who's right and prepare an analysis of the legal issues and an explanation, importantly, as to your reasons. Question 2, I will give you a legal concept, but in response, you'll need to discuss a number of issues that generally relate to property law in terms of alienability, which is transferability, exclusivity, use or enjoyment of property, property rights, and property interests. So it's a very generalised type question that you can expect in question 2. And question 3 deals specifically with estoppel. We haven't talked a whole lot about estoppel, but I'm keen to have you explore this in a great deal of detail, and that's why I've allocated a full question to this topic, because estoppel is important not just in property law, but it's an ongoing theme. So let's explore that in this question and get yourself well prepared for that. I won't tell you what aspects of law relating to estoppel are in the exam, but there are 5 aspects that I want you to consider within that. So are there any questions in relation to the exam or what's required of you in that exam?
Could I ask a question about question 1?
Yes, Amy.
So just with the judgment format, do you still want us to lay out the IRAC headings, or would you prefer us to use the more sort of judgment style layout?
Judgment style layout.
Okay.
So I want you to keep in mind the IRAC methodology, but I don't specifically want you to, I say slavishly follow it, because we just don't see that typically. And by now, I suspect that you've probably got some of your favourite judges. Back in my day, it was always Lord Denning, but there are different judges who write in different styles. And if you find a case that you thought, wow, this is really easy to read, that's probably the type of format you should follow, because you know that I'm looking for something which is readable, where you deal with the issues and you express yourself plainly and directly. That's the style that I like to see in a judgment. So don't be concerned about it having to be overly sophisticated, for want of a better term, because I think the simplicity shows the better quality and the better grasp of the subject than something that is, difficult to read. I hope that makes sense, Amy, in answering your question.
Yes, thank you.
Any other questions, comments? All good?
I don't
Yes,
know
Amy?
if it's relevant or not, but I actually ended up having a look at the Australian Institute of Judicial Administration and had a look at their documentation, which just gave you sort of a really good overview of how judgments are written. I don't know if you know that one.
That's an excellent resource. That's a very good find, and I'd urge you all to look at that. So well done, Tammy. And of course, there are plenty of templates, because you just need to find any decision, and that is, in a sense, a template, isn't it? So Jemima asks, Tammy, if you could just repeat the name of the resource.
Yeah, its abbreviation is AIJA, but it's the Australian Institute of Judicial Administration Incorporated. And it's quite a lengthy document. I think it's about 66 pages, but it does give you some really good sort of concepts or understanding of how an actual judgment is written. It goes through like noting up and catchwords and all of those sorts of things. I mean, a lot of it might not be relevant for this assignment with regards to the word count, but I just think when I was reading it, it just gave me a really good overview of the understanding of how a formal judgment is written, and I guess then we just try and manipulate it to work within our word count.
Excellent. Thank you, Tammy. And I should just mention, even though catchwords are typically included in a judgment, I don't expect you to include catchwords for this assessment. And if you're wondering, the catchwords are usually provided so that they comply with the general requirements of legal platforms. For example, in the tribunal, we follow I'm not sure if it's LexisNexis or the alternative, but it's along those lines. So that's very wordy, I'm sorry. Any other questions, comments in relation to, Thomson Reuters is what I was looking for. Any other questions or comments in relation to the exam? All good? And Tammy's just put up the reference to the AIJA in the chat.
There's another good one that I also found, which was from the Supreme Court of the Queensland Library. If anyone's interested in having a look at that one also goes through a bit of judgment writing as well.
Thank you. The Supreme Court Library, Queensland. Excellent. All right. Well, look, let's just wrap up by talking about some of the general techniques that you might want to consider in terms of preparing for the exam and writing the exam. Self-management skills is always an important topic. I may have mentioned at the outset that law students do suffer a considerable amount of stress. That's not just me making an anecdotal statement, but it's as a result of various studies that have been conducted. So in the next week or two in particular, do look after your mental health, your well-being. You know that you'll be under pressure. And what I've attempted to do throughout the entire unit is prepare you for the exam next week. I'm not trying to put extra pressure on you, but just say that the idea of having the first assessment, the toolkit, the procedure for answering a question is all designed to make next week a little easier. But if you do feel that you're under pressure, don't be overly concerned, but do take care of yourself, maintain the healthy lifestyle, and remember that it is best to try to prepare for the assessment. That's always an important thing. And if you don't understand what I mean by that, do have a look at my preparation video in terms of how to prepare for an exam or a short window take-home paper. Remember, of course, to follow the basic rules, IRAC methodology, and if you're dealing with a statute subject to the specific provisions of the statute concerned, remember your rules relating to statutory interpretation and keep in mind the relationship between statute and case law, and also remember the basic jurisdictional questions such as state or Commonwealth and identifying the areas of law. What I've tried to do, particularly towards the end of this unit, is identify that property law is not, should not be considered in a standalone context, but it does have an interplay with other areas of law, such as torts law and consumer law. So you should have a clear idea of the process that you plan to adopt in writing your response, particularly to the problem question. And remember, of course, that if you're the judge trying to work out who's right or wrong, a good way of doing that, once you've identified the material and relevant facts, is then to try to identify the relevant legal issues. And it may be that there are a number of issues based on the facts. And when you identify the issues, it's likely that there will be certain elements that you need to be satisfied of before you can say that that legal issue is relevant to the task. So try to identify the elements that might be relevant. So, for example, if you were considering a contract issue, you'd have the elements in mind: offer, acceptance, consideration, intention, to be legally bound. You may not specifically refer to that in your decision or your judgment, but at least you'd have that as part of your checklist so that you're not missing something that might be, in hindsight, an obvious issue. And one of the best ways of doing that is to have a well-constructed and thoughtful toolkit, checklist, available to you. And that's particularly relevant when you're trying to work through a complex scenario, because you'll be drawn in a whole range of different directions. So you need to create some structure and clarity and ultimately answer some questions. So questions might be, look, what happened? Who was responsible? Why did this happen? When did it happen? Where did it happen? And some of those things are relevant to overcome threshold questions relating to jurisdiction and limitations that are always in the background and not always relevant, but something that you should at least check off in your checklist. It may be that if you can't answer some of those questions, you may need to make some assumptions. And if you do make an assumption, state that. If there's an absence of some material facts, then don't be afraid to call that and say that the facts as stated don't deal with this, so I'm going to make this assumption, for example. And particularly for the first assessment, you do need to make a clear conclusion. And it may be that your conclusion is incorrect, but you do need to make a strong conclusion. And can I say that I was particularly impressed by this cohort's ability to come to a clear conclusion in relation to the problem that I'd set for the second assessment. Now, when it comes to writing, not just in this unit for the assessment, but generally, as you know, I do want you to write in a plain and direct style. So what that means is that sometimes lawyers, particularly in the past, were guilty of creating bewildering documents. By that I mean the documents were too wordy, there was material that was redundant, it included legalese and unfamiliar words and pompous terminology, and it was poorly organised. So a document should be something that is plain and easy to read wherever possible. Now, from a review article by Thomas Word, one that I use when teaching advanced statutory interpretation and legal drafting, I'll just give you an example. And in the article, Mr. Word says, look, here's an example of the wording that's used in a will. I, John Quincy Doe, now residing in the city of Richmond, state of Virginia, being of sound mind and memory, do hereby make, publish and declare this to be my last will and testament, hereby revoking, annulling and cancelling any and all wills and codicils heretofore made before me. I mean, that's the sort of wording that you often see associated with lawyers. But instead of all of that, you could simply say the same thing by saying, I, John Quincy Doe of Richmond, Virginia, make this will and revoke all earlier wills and codicils. It says the same thing, but you get the idea. It's to the point, it's direct. So avoid adding words that are unnecessary. Avoid writing in the passive voice. If you can write in the active voice, do that. When it comes to preparing a decision, it's a bit like preparing an agreement. Now, I'll give you an example of the way in which lawyers write badly when it comes to writing an agreement. Because lawyers will say things like, this agreement is entered into in circumstances where the parties agree as follows. And then the next paragraph is, number one, it is agreed that. Number two, it is further agreed that. Number three, it is expressly agreed that. It just clutters it in circumstances that it's unnecessary. And in fact, sometimes writing like that creates an opportunity to attack the wording, because the argument might be, well, they wouldn't have included the different terminology if they didn't mean it to be something other than what would seem to be obvious. Using poor structure is sometimes important, and not using the power in the Word document to spell check and grammar check is always important as well. So just remember that when it comes to marking an assessment, what I want to see is something that makes sense from the outset, as if I hadn't read the the material previously, so that I can understand what you're saying in a logical and clear manner. And you'll get better marks from me for that than writing in an extravagant manner, for want of a better term. All right. So that's all that I wish to propose to say about legal writing. Before I move on, we're getting close to the end now. Are there any questions about that? You all understand what I'm getting at? All good? All right. If you have any doubts as to what I mean by how to prepare in the next week, please look at my video Level 3 examination or short window online paper preparation, and you'll see what it is that I expect that you might do to prepare at Level 3 standard. Now, when it comes to writing, you will need to use some formal language at times, but try to minimise that. Do write in complete sentences. Sometimes I see people write in dot point form, which you should generally try to avoid. And remember, of course, that if I ask you to analyse, that's different to examine, that's different to describe, that's different to evaluate, that's different to consider or investigate. So be aware of the first words that I use, and I think I've given you a fair hint already in the exam preparation guide as to the type of assessment work that I want you to produce for me. And in the problem-solving question, of course, it is important that you consider the arguments from the perspective of all parties concerned, which was something you needed to do in the second assessment. And can I say that generally people answered that very well by looking at the problem from the perspective of a range of parties. So in conclusion, when it comes to writing the assessment, please avoid long-winded, wandering answers. Be direct. Remember, of course, that you'll obtain the first 50% of the marks in the assessment more easily than the second 50%, and the most difficult 20% of marks are the final 20%. Just watch the word count. You don't have to repeat the question per se. Do write professionally. Watch your grammar, watch your spelling, punctuation, and I think you all know that I like the professional layout of the material. State the conclusion, and in the problem-solving question, answer with conviction. Before you submit the work, if you've got time, do proofread it. It means probably silently reading each word, running it through the Word program if you can. One other thing you can do, as a little tip, is you can have a text to voice translation running, and the translation will read it for you, and it might be more obvious if you see anything that doesn't make sense. Right, well that concludes the unit. Unless there are any questions, I will ask a huge favour, and that is, if you haven't provided feedback for the unit already, would you please do that now? It's very important for the university. It's certainly very important for me. I would love to see 50% of the cohort provide feedback. It should only take you a few minutes, and I'd urge you to do that now. We're going to finish early tonight, so you've even got time tonight to do that. So please provide feedback, not just for me, but for all of your unit coordinators. Now, before I wrap up, finally, are there any questions? All good?
I
Yes,
can
Tammy.
highly recommend your video. That's helped me right from day one. Your level 3.
Level 3. Thank you very much, Tammy. I appreciate that. Any other questions, comments? All good?
No,
All right.
thank you
Yes,
for
great.
everything.
Thank you. All right. Well, as usual, I'll upload this recording, and all the best. I hope you enjoy undertaking your work next week, and good luck in this unit and all of the other units that you're taking. So all the best.
Thank you.
Bye then.
Thanks.